Hey guys, welcome back to my channel where I try to break down complicated immigration ideas into a simple to understand platform. Today we're going to talk about petitioning for a spouse or child who's outside of the United States. We're going to be talking about the forms you need to file, the procedure, and some generally asked questions that I regularly receive. If your spouse and children or stepchildren are outside of the United States, generally speaking, an I-130 petition for alien relative is necessary for each of them. So if you're a US citizen and your spouse is outside of the US and your stepkids are outside of the US, you would file a separate family petition for each family member. Now, there are some exceptions to this, and it can be kind of complicated, so it's important to speak with an immigration lawyer, but I'm going to try to explain some of them in this video. One of them is, if your biological child is born outside of the United States, there is a chance that that child is already a US citizen if you're a US citizen. In that case, you can just register the birth of the child at the US embassy or consulate abroad and then get them a US passport. You don't need to go through the whole immigration process for the child, but you still would for your spouse. So that's the first thing to keep in mind. A question I commonly receive is, can I petition for a stepchild or a step-parent? So I just want to explain what the difference is between a regular relationship, so like a father-child relationship, and a father-stepchild relationship, for example. There is no real difference. If the parents get married before the child's 18th birthday, a parent-child relationship for immigration purposes is created, and you could petition for that family member in the way you would for any other family member. And the same thing goes for step-parents. So US citizen sons and daughters, so children who are over the age of 21, can petition for their parents. But if that child's parents got married before the child was 18, so let me give you an example. Let's say a child is 16 years old and the child's biological father remarries. And so now that child has a stepmother. That child and that mother create a child-mother relationship. Doesn't matter that it's the stepmother. Since the marriage happened before the 18th birthday, that child, when that child reaches the age of 21, can petition for that stepmother in the same way that that child would for any other parent. After I explain this whole step-parent, step-child relationship to my average client, their next question is, yeah, but we got married after the child's 18th birthday. Can we still file a petition? Can that child still petition for a parent or other way around? And the answer is no. Unfortunately, for immigration purposes, there is no relationship created by that marriage in these instances. Another common question I'll receive in this type of situation is, well, like my wife abroad is going through some difficulties. She's pregnant. She's dealing with some family issues. Is there any way I could speed up this family petition to bring her over here more quickly? And the answer is no. There's really no way to speed up an I-130 family petition that is in ordinary processing times. You can look up the ordinary processing times of each type of petition on the USCIS processing times website, and you won't really have much recourse if the petition is in the normal course of processing times and isn't dramatically outside of these processing times. Now, you have filed an I-130 family petition. It goes through the whole process. Eventually, it gets approved. What happens next? Well, next, it'll get transferred to the National Visa Center. You'll receive a case number and an invoice ID number. You log into the Department of State's website, pay some fees, fill out immigrant visa applications for each immigrant who's trying to come over to the United States. And then eventually, once the National Visa Center is satisfied with all the documents and you've filled out all the paperwork, they'll transfer it to the US Embassy or consulate in the country where your family members are residing. At that point, they need to schedule an interview with the consulate, get the medical exam, jump through some additional hoops. Eventually, there will be an interview, and if all goes well, your family members will get what's known as an immigrant visa stamped into their page put into their passport. They would then use this to enter the United States, and when they enter the United States, on that day, they become a permanent resident and a few months later, after filling out another form, the green card will eventually be mailed to their address of residence. There are some situations in which you don't need to file an I-130 family petition while your spouse or child are abroad. Sometimes they might be eligible for adjustment of status here in the United States. So before you take the step of filing a family petition, which may impact their ability to freely travel back and forth, for example, on a tourist visa, it's important to speak with an immigration lawyer, even if you plan on doing this all by yourself, so that you can at least create a plan. All right, guys, I try to break down complicated immigration topics into simple, understandable ideas. If you like these topics or want to propose some other topics that you want me to make videos about, be sure to write it in the comments below. Be sure to subscribe, and I'll see you next week for another immigration video.